Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
So, hello and welcome to episode 185. It's been a while, hasn't it? My apologies about that. I was away in Italy for 3 weeks, and then when I came back, there have been a number of matters that have claimed my attention. So, as I say, my apologies. I hope someone out there missed me. Anyway, we're back with 3 cases. The first is looking at an attempt to use GDPR, data protection, human rights, and anything else that occurs to me to prevent an employer from processing information about my possible criminal offence. The second shows the development of the Royal Mail and Duty case, which, if you remember, was the Iago witness. And then we've got a case dealing with a dismissal for a breakdown in relations between a manager and an employee. Finally, I've got a book recommendation for you, since we haven't done that for a while either. Please don't forget that the podcast is available via iTunes, on the Mayer Brown website or YouTube, and the Twitter feed Nicholas Robertson at Nicholas ROBER11, and we put out links to the cases there. We're also now on Spotify, Google Play, Yahoo, etc., etc. So, first case, Hopkins and the Commissioner for Her Majesty's Revenue and Customs. As a gross generalisation, one of the things that I've noticed over the course of many years of practice is that employees accused of misconduct, or indeed facing any disciplinary proceedings, broadly fall into 2 categories. There are those that are outraged at the suggestion they've done anything wrong, and who choose to engage head-on with the merits of the allegations against them. They want to get matters to a conclusion quickly because they're utterly convinced that they are right. Bring it on. On the other hand, there are employees who may protest equally vehemently their innocence, but whose predominant strategy seems to be to draw matters out. They contest the disciplinary proceedings by throwing up as many procedural obstacles or legal obstacles as possible to avoid getting to a conclusion, in the hope that the employer will, presumably, give up or accept a less adverse outcome. One of the obstacles you can see thrown up by an employer is reliance on the rules relating to data protection or human rights. The Hopkins case, saw a whole slew of objections and obstacles being put up by the individual. Now, clearly, I don't know anything more than one reads in the case, and so whether or not the claimant herself in this case was keen to get to a hearing and was frustrated that wasn't happening, or was engaging in scorched earth block and trap tactics, I don't know. What is clear, however, is that a lot of the points that she took in connection with her case feature in some of the correspondence that we have seen from time to time from individuals who are undoubtedly seeking to delay or avoid the employer getting to a conclusion. The background is that the claimant is a civil servant employed by HMRC. The case report is very circumspect about the details, but she was arrested in August 2018 by the Merseyside Police and was then on full pay and suspended by HMRC pending disciplinary proceedings. She's not been charged at this point with any criminal offence, but equally the police have not said they're not going to be proceeding, so the investigation is ongoing. Likewise, although she's been suspended, no disciplinary charge has been laid by HMRC. So since we're more than 2 years after the event, that must be extremely stressful for her. Anyway, the case concerns the claim by Dr. Hopkins for misuse of her personal data, including data relating to the potential criminal offence, her alleged breach of contract, and she's also asserting there's breach of her human rights in relation to her suspension and the disciplinary process so far. I think it's worth looking at some of these to illustrate the way the court deals with them. A word of caution, however, there are many points in this case, so I'm going to cherry pick out some of them. Her entire case faced a strikeout or summary judgment in the defendant's favour, either because there were no reasonable grounds for bringing the claim or there were no real prospects of succeeding on the claim or issue. Going into the facts in a little bit more detail, claimant was arrested on 15th August 2018, and in line with her contract of employment, as she was obliged to, she disclosed to her line manager she'd been arrested. The line manager disclosed the information to Internal Governance, which is a division of her employer, and 2 days later she was suspended. She was then told she was the subject of a disciplinary investigation by a manager within the Internal Governance section. She was told that this was potentially gross misconduct. At that point, she said her mental health deteriorated and she was on sick leave for stress. She then announced that she was bringing a grievance and refused to communicate with the manager appointed for the investigation, but she did communicate with another member of HMRC in connection with the allegations. This then mutated into a grievance relating to the lawfulness of her suspension, the investigation, and the challenge, as I say, was based on the General Data Protection Regulations and the Data Protection Act, and she made a complaint to the ICO. The complaint to the ICO led nowhere, but this, the case, is the case she brought directly against her employer, alleging breach of various rights. Speaking broadly, the claimant targeted, effectively, the obligation on her to disclose the information in the first place, then what HMRC had done with the information, and the lawfulness of the disciplinary proceedings based on her disclosure, but also on information provided by the Merseyside Police to her employer. She made the challenge, I should say, based on GDPR, the UK's data protection legislation, human rights, and other legislation as well, which I won't go into. As I say, the case is quite lengthy and complicated, and for the most part, every one of her allegations was struck out, with some limited exceptions. The court started with the claims that her contract of employment had been breached before moving to the data protection complaints and then the claims based on the European Convention on Human Rights. It probably makes sense to deal with them on the same basis. Her contract of employment required her to comply with the Civil Service Code and HMRC, her employer's, Code of Conduct. That in turn required her to disclose to a manager if she was investigated for any criminal offence. The HMRC guidance note went slightly further in that it required her to avoid any conduct in her private life which might bring HMRC into disrepute or affect poorly on her as an employee of HMRC. And again, it reiterated that she had to provide details if she was arrested or involved and or investigated for any criminal offence. There was a very detailed staff privacy notice which enabled the processing of information for the purposes of performing the contract with the individual and to enable HMRC to comply with its legal obligations to carry out its functions as a government department or where it may be necessary to do so in the public interest. It's a pretty detailed and thorough staff privacy notice. The first attempt by the claimant was to argue that her suspension was in breach of HMRC's policies or ACAS guidance, but this was rejected by the court given the serious nature of the offences for which she'd been arrested. Therefore, those claims were struck out. It was accepted by the court that the length of time that she was being suspended for, which remember was 2 years, might give rise to a claim, and so that survived, but that was a rare success for the claimant. Claimant tried to argue that the disciplinary investigation was unfair and a breach of policy. Again, the court was having none of this. The disciplinary investigation process had seen her invited to provide her version of events during an investigative interview, which was being held in accordance with the disciplinary procedure. She was given the opportunity to answer questions in writing if she didn't want to answer them verbally. There was nothing to prevent her explaining her position if she wished to do so. Therefore, attempts by her to argue that the disciplinary investigation was unfair or in breach of policy, they were also struck out. Turning now to the GDPR data protection claims, the basic allegation was that the claimant said the employer's processing of her personal data in relation to the alleged offence was unlawful. She put the same point multiple ways. She tried to argue that, in some respects, HMRC was a data processor rather than a data controller. Her employer, HMRC, had been passed some information about her alleged misconduct by the Merseyside Police, and she tried to use this to say that the police information was being processed by her employer as a data processor rather than a data controller. But the court pointed out that a public authority which, alone or jointly with others, determines the purposes and means of processing personal data is a data controller and is not a data processor. HMRC here was not processing the data they'd been given by the Merseyside Police on behalf of the Merseyside Police. It was processing the data for its own purposes. So that claim failed. It was agreed, of course, by both parties that the information relating to her arrest was information about a potential criminal offence, and so it was clearly information which was subject to the heightened requirements, if you can put it that way, for lawful data processing. The claimant said, and this is really at the heart of the claim, there was no lawful basis for her employer processing this data for the purpose of suspending the claimant or instituting disciplinary proceedings against her, and she asserted this was a breach of Article 5 and 6 and also the data protection legislation. Looking at the GDPR for a second, Article 5 of the GDPR requires personal data to be processed lawfully and fairly. Where data is sensitive personal data, which covers alleged criminal offences. Under Article 6, the relevant part of Article 6 provides that the processing is lawful to the extent that it is necessary for the performance of the contract which the data subject is a party to, or is necessary for compliance with the legal obligation to which the data controller is subject. Data Protection Act provides that processing can be undertaken if it is necessary for the purpose of performing or exercising obligations or rights which are imposed or conferred by law on the controller or the data subject in connection with their employment, and the process is carried out under an appropriate policy document. There are specific additional provisions relating to the investigation of data processing, relating to unlawful and alleged unlawful acts of dishonesty, where processing can be undertaken if it's necessary for the purposes of complying with a regulatory requirement. Since the court struck out the allegation that the disciplinary investigation was unfair and in breach of HMRC's own policies, it followed, in the court's opinion, there is no realistic prospect of her succeeding in a claim that using her personal data for the purpose of disciplinary proceedings, including the decision to suspend her, was unlawful for the purposes of GDPR. The court looked at the staff privacy notice and decided that it met the definition of an appropriate policy document. Nothing daunted, the claimant also argued it was inappropriate to have shared her personal data with the internal governance team after she had provided the data to her line manager. Having found that the processing of her personal data for the purposes of the disciplinary investigation did not breach Article 5 of the GDPR or breach the Data Protection Act, there was then no problem with the court also striking out the claim that sharing information with the internal governance team who are going to undertake the disciplinary investigation was also acceptable. Similarly, it was legitimate to brief HMRC's press office given the nature of the allegations and the potential for adverse public comment. The claimant had also asserted that data had been shared with senior management at HMRC, but as the court pointed out, that was legitimate because Dr. Williams had herself written to those senior managers making known her concerns, and so this was information provided to them to enable them to prepare a response. Similarly, the suggestion by the claimant that the contractual requirement to provide information ancillary to her to her employer was a breach of Article 5 of the GDPR. Well, this failed too. Given it was not a breach of her contract for her to be required to do this, the court took the view that the claimant's core contention, which was that HMRC could not lawfully investigate conduct that was alleged to have taken place outside the workplace, failed, and so again the attempt to rely on the GDPR to block the investigation, that also failed. The claimant also sought to rely on provisions of the European Convention on Human Rights, and here she fared no better. Leaving aside her forlorn attempt to argue she is being subjected to torture, inhumane or degrading treatment or punishment contrary to Article 3, which, let's face it, was never going to fly, here too the court took a robust approach to her arguments. She complained about alleged breach of Article 6, which looks and requires a fair process for determining her civil rights and obligations, but the court said that didn't apply because HMRC disciplinary proceedings are not a determination of her civil rights. Article 8, the right to private life, likewise was not engaged. The requirement to disclose the information was not a breach of the right to privacy because it complied with her contract and those policies and procedures were in line with the GDPR and the Data Protection Act. Her attempt to argue that recording and transcribing the disciplinary interview was a breach of her human rights similarly failed, given she was invited but not required to attend the investigation. She was allowed to provide a response in writing if she wanted, and she was told more than once the interview was being digitally recorded to ensure it provided an accurate record. In short, her attempts failed in all meaningful senses. Clearly, rightly or wrongly, the case reads to me as if it's a kitchen sink case, i.e. the claimant is taking every single possible point she could think of. But it's a very useful illustration of the court permitting an employer to process data and investigate allegations of misconduct outside work, undeterred by the GDPR, data protection legislation, human rights considerations and so on. Now, that's not to say that those just can be ignored. Far from it. It's that the point I'm making is an employer who's taken sensible steps ahead of time to ensure there's an appropriate privacy notice and is processing data for obviously sensible reasons is not likely to be defeated by a technical or obstructionist interpretation of legislation taken by a claimant. My suggestion is that if you are involved in a case where the other side are making some of similar points to this is a very useful case to have as a reference point, as it does go through the legal issues in some detail, extensive legislative references and so on, and I can't do full justice to them in this summary. So that's the case of Hopkins and the Commissioners for Her Majesty's Revenue and Customs. Mr. Udin and London Borough of Ealing. This is an unfair and a wrongful dismissal case which develops, I think, the case of Royal Mail and duty in an entirely logical but nevertheless possibly slightly problematic way for employers. The underlying facts were that the claimant had been part of a group of employees who'd gone out for a drink after work. Late in the evening, after apparently a lot of alcohol had been consumed, the claimant and a junior female employee ended up in the disabled toilets together. What happened in there was disputed. She asserted in the next few days after the incident that she had been assaulted by him. This was not admitted by the claimant. There was CCTV footage which showed the group gathering and then their absence in the disabled toilet. The claimant also had significant bruising to her upper body after the encounter and provided a photograph of this. When the allegations became known to the employer, it encouraged or indeed urged the complainant to go to the police with her account of matters. A couple of months after the interview, the claimant therefore did go to the police, but after an initial interview, she said she wanted to speak to a solicitor before taking it any further. She also said that she wanted to withdraw the allegations that she'd made because it was, quote, so griefy, unquote, and she had felt pressured by the company into coming to the police in the first place. She apparently also signed a short withdrawal statement saying she didn't remember being assaulted. In the meantime, claimant had been suspended, and an investigator did what looks to be a very thorough job here into a situation which, at the heart of it, was a situation where there was no external evidence, and it was one person's word against another about crucial events. I'll come back to that point in a second. The claimant then faced disciplinary proceedings for misconduct. He was dismissed, he appealed, and the internal appeal was unsuccessful. The Employment Tribunal, considering the case, dismissed his unfair dismissal complaint. In a majority decision, the tribunal concluded the dismissal was fair overall. Crucially, the investigator had been made aware that the female employee who had allegedly been subjected to the assault had withdrawn her complaint to the police. He knew about this after he'd submitted his report, but before the decision to dismiss was taken. And you can see where this is going, can't you? For whatever reason, he did not tell the dismissing manager, and similarly the claimant and his advisor was unaware of this at the time. The Employment Tribunal decided this did not affect the fairness of the dismissal because the claimant could, in any event, have been fairly dismissed if no police complaint had ever been made. So, there are obviously a number of grounds of appeal to the Employment Appeal Tribunal, but the two which I want to focus on are the appeal against that aspect of the Tribunal's decision, and then an appeal based on the fact that the evidence against the claimant, it was said it was too scanty to permit a wrongful dismissal finding against the claimant. The first, of course, is the duty point, so let's start there. The EAT point out that the key starting point, of course, are the words of Section 98.4 of the Employment Rights Act 1996. The determination of the question whether the dismissal is fair or unfair depends on whether in the circumstances the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee and is to be determined in accordance with equity and the substantial merits of the case. The EAT pointed out it was necessary to consider the fairness of the end-to-end process, including any appeal. The EAT also made clear that in their view, when looking at whether there had been a reasonable investigation conducted by the employer, this obligation does not end at the point at which a formal pre-investigation report is delivered. The duty of ensuring the investigation has been reasonable continues up to and it includes the decision to dismiss at the disciplinary hearing itself. It was no answer, therefore, that the investigator had only learnt about the withdrawal of the complaint to the police after he delivered his investigation, because he learnt about it before the decision to dismiss. The EAT was clear that the duty case was applicable here. Well, its principle was. Duty was concerned with a manager who manipulated an innocent manager into selecting an incorrect reason for dismissal. So the duty case went to the reason for dismissal. But here there was no suggestion the investigator was malicious. Equally, his omission did not affect the reason for the dismissal. It went to the fairness of the dismissal. Nonetheless, the EAT was clear that it was relevant to consider the knowledge or conduct of someone other than the person who actually decides to dismiss when deciding the fairness of the dismissal. Therefore, since the tribunal should have considered the fairness of the disciplinary process from end to end, the EAT concluded it was an unfair dismissal because the investigator had not disclosed material information known to him. Frankly, the employer's case was not helped by the fact the dismissing manager in evidence said she had taken into account the fact of the police complaint by the female employee, and she would have wanted to have known the reason behind that complaint to the police being withdrawn had she been aware of it. The AT judge had little time for the argument that the Employment Tribunal's majority had adopted when saying the dismissal was fair, that it would have been fair even if no complaint had been made and therefore the fact the complaint had withdrawn was irrelevant. The two situations were not analogous, and the disciplining manager's evidence indicating she would have wanted to be aware of the reason for the withdrawal was, in my terms, fatal to the employer's contention at the AT. Fairness and equity required that both the disciplining manager and the claimant and his representative were made aware of these facts. As such, and bearing in mind the importance of heightened standards of fairness given the nature of the misconduct in question, the AT determined this dismissal was unfair. The matter wasn't remitted to the tribunal, it was unfair. End of. However, there was an attempt by the claimant to overturn the finding that he had not been wrongfully dismissed. In other words, what he was wanting to say is that his dismissal, which was summary and without notice, was a breach of contract because he wasn't actually guilty of the misconduct in question. Let me explain. Of course, the difference between the unfair dismissal test and the wrongful dismissal test, it is an unfair dismissal, broadly speaking. The issue is whether or not the dismissal is fair because there's been a reasonable investigation and there are reasonable grounds for honestly believing the misconduct has taken place. In a wrongful dismissal, breach of contract case, it's necessary for there to be a decision on the balance of probabilities that the wrongful conduct actually took place. In the one, reasonable grounds are enough, in the other, balance of probability, and that's a different standard. It's a higher burden of proof for the employer in a wrongful dismissal case than it is in an unfair dismissal case. The AT accepted that it was open to the Employment Tribunal to find on the balance of probabilities that the assault had happened. This was notwithstanding the withdrawal of the complaint and the grounds that were given by the female employee for doing so. The photographs taken by the claimant showing the bruising caused by the alleged assault. It was open to the manager to find on the balance of probabilities the bruising would not have been caused by a fall. Therefore, they were consistent with the assault having happened as the claimant said. So, therefore, based on the photographic evidence of the assault, it was a finding open to the Employment Tribunal to reject the claimant's breach of contract claim. Now, my reason for including the case is because I think the comments about the relevance of the information known to the investigator are very important. It's clearly not a very sympathetic argument for the employer to have to run to say that relevant information known to the investigator was not passed on, but that did not affect the fairness of the dismissal. I suspect the point wouldn't even have been contested if the investigator had known during the investigation itself of the withdrawal of the complaint to the police, but had not passed it on. To that extent, I think it's entirely logical that the AT allowed the appeal. But it does mean that investigators are going to be under an ongoing obligation, if they become aware of relevant material, to pass it on to the disciplinary process, even if their investigation role has ended at that point. I do wonder how much further this can go. We've had a situation where a line manager, not involved with the dismissal process, manipulates the dismissing manager into a false reason for dismissal duty. We now have a case where the investigator has failed to pass on relevant information. It's only a short step if a line manager who's not part of the investigation but who knows material matters fails to pass on evidence. Will that too have an impact on the fairness of the dismissal? Work colleagues may not wish to get involved in the matter, for example. Clearly all of this will be filled out over time by fact-sensitive cases, but I do think it's a point that employers need to be aware of, particularly in relation to misconduct cases and also in relation to the scope of their investigation. Clearly an employee who, unknown to the employer, chooses not to tell the manager something might affect the outcome of the dismissal. Alternatively, it might be viewed as they are sufficiently junior that it doesn't matter and there is no obligation on them to say anything. But I think it's important that employers are aware of these issues. Secondly, the AT's approach to the tribunal finding on wrongful dismissal is illustrative. I don't think it creates any new principles of law or anything like that, but these sorts of cases come up more often than you'd think. They're immensely difficult to deal with, particularly as a basic conflict of evidence between two individuals and very little corroboratory evidence. Here, the AT accept the Employment Tribunal could find on the balance of probabilities the assault had taken place, and this is based on pretty limited but relevant contemporaneous documentary evidence. It's always fact sensitive. We had one case a few years back where we advised a client on a case where the entire incident, let's say assault, maybe that's being a bit simplistic, but the whole incident was caught on CCTV camera in the relevant nightclub. But the whole question was the intent with which the contact had been made between the two employees, which of course was not a question that was easy to answer from the CCTV footage at all. So, that's the case of Udin and London Borough of Ealing. Gallagher and Abellio ScotRail Limited. Abellio? Tomato, I'm not sure. Anyway, this is another EAT case and concerns someone who was dismissed without any procedure. And it was about whether or not the Employment Tribunal could find that the dismissal was fair. What happened was the claimant had worked for her employer for 10 years, up to the point where she was dismissed. For 6 of those years, she'd reported into a Ms. Taggart. Initially, that working relationship seems to have been good, but from 2014 onwards, things seem to have deteriorated. So, for example, Ms. Taggart expected all her direct reports to participate in an on-call rota, and the claimant refused to do this. There are arguments about who was to be recruited into the team, and this seems to have set up some sort of festering situation. The claimant blamed Ms. Taggart for what was going wrong. Ms. Taggart was increasingly concerned about the claimant and whether or not she was happy in her particular role. Problems were exacerbated by the fact that Ms. Taggart was under significant business pressure at the time because she managed a significant portion of the business and the business was entering a critical phase where she was expected to deliver on certain business objectives. As a result, Ms. Taggart spoke to HR and indicated she thought there had been a breakdown in trust between her and the claimant and that this was not recoverable. The context was the need to deliver against key business objectives, and she said she didn't feel that could be done with the claimant remaining in her current role. Ms. Taggart told HR that she'd been looking for a number of months for alternative roles for the claimant within the company, but nothing had come up. The claimant too had been looking for roles, and she too had found nothing else within the company. Therefore, Ms. Taggart suggested to HR that the only alternative was for the claimant to be dismissed. The company considered whether or not to go through a disciplinary process, but took the view that, given the decision had in effect been taken, it's not really a matter of conduct or performance management, where following a process might help matters. So the company decided simply to notify her she was being dismissed. The claimant was given no warning, and at a pre-arranged annual appraisal meeting in April 2017, she was just dismissed. The claimant, unsurprisingly, was unhappy, but didn't dispute that the relationship with Ms. Taggart had broken down. She didn't suggest mediation, joint counselling, she didn't raise a grievance. There was no right of appeal against the decision, so obviously she didn't try to appeal it. So, unsurprisingly, the case goes to unfair dismissal for an unfair dismissal claim. There was also a claim for discrimination, which I don't propose to go into. And if you were the claimant, you would presumably have gone into this tribunal thinking you had a really pretty strong unfair dismissal case. No warning, no process, no appeal. However, the Employment Tribunal ended up ruling against the claimant. The respondent's witnesses were apparently found to be very credible. The claimant was found to be someone who was viewed as less credible, since her version of events that she was now presenting was at odds with what happened at the time. The tribunal accepted there was no longer trust and confidence between the claimant and her manager, Ms. Taggart. Ms. Taggart had also spoken to the claimant's direct reports, and they too had expressed concern about the claimant and her actions. The tribunal, as I say, found the dismissal was fair. In particular, they said there were significant issues between the pair of them. They both worked at a senior level in an important part of the business, which was under high pressure and public scrutiny. It wasn't being suggested that there was misconduct by the claimant. It was not suggested the claimant's conduct had caused the breakdown. The fact was they simply had different opinions about what was to be done, and the claimant had been particularly stubborn about sticking to a viewpoint rather than moving on. The tribunal accepted the reason for the dismissal was a lack of trust and confidence, which is a barrier to delivering the objectives of the business. Therefore, the dismissal was for some other substantial reason. The tribunal agreed that none of the company's internal processes, nor the ACAS Code of Practice, applied to a breakdown of trust and confidence between two senior managers. The tribunal accepted that a procedure would not have served any useful purpose in the circumstances, and indeed, according to the tribunal, quote, if anything, it would have been worse than the situation. Unquote. Presumably, the tribunal had the idea that the situation would then, if they'd followed a process, would have forced two people who are now openly talking about one of them leaving the organisation on the grounds of a breakdown in trust, having to work together for a period. Doesn't sound terribly happy. Tribunal also noticed there was no evidence that the claimant at the time was interested in retrieving her relationship with Ms. Taggart. Unsurprisingly, claimant appealed to the AT, and in particular targeted the suggestion that the dismissal was fair. She laid particular stress on the fact that she wasn't given any notice that the annual appraisal meeting was to discuss her dismissal, and she was not given any opportunity to respond to the decision to dismiss by way of appeal or otherwise. The employee also argued that precluding any right to appeal would seem to take the dismissal straight outside the band of reasonable responses. The AT, in looking at this, said that in many cases failing to follow any process for dismissal would mean the dismissal was unfair. But here, the tribunal had gone into the process carefully, had given itself a proper self-direction to consider whether or not the dismissal would be fair in the absence of a process, and had come to a finding, which was open to it, that an ordinary process would have made things worse, not better. This was a case involving two senior managers who needed to be able to work together effectively in order to deliver what the business needed at a critical juncture. It was a finding of fact that was open to the Employment Tribunal, and therefore the appeal failed. I wouldn't want anyone to take away from this the suggestion we now have a class of dismissals where it's safe not to follow a process or to even have an appeal process. These were exceptional circumstances. I think the fact the claimant was a senior manager, as well as her manager, probably counted against her. Equally, the fact the business was at a critical juncture and trying to deliver a project undoubtedly counted for something. But I think it's primarily noteworthy that it was not suggested the claimant caused the breakdown in the relationship. Both parties had lost trust and confidence in the other, and that was sufficient to allow the dismissal to be found to be fair. Maybe it's a valid pointer where the employer feels unable to follow a process for fear of making things worse that a tribunal might be sympathetic, but it's always going to be very much the exception and not the rule. So that's the case of Gallagher and Abellio Scotland Limited. So, thank you very much for listening. I promise the next episode will be along rather more quickly than this one. In the meantime, I said I'd leave you with a book recommendation. How to Be a Liberal by Ian Dunt, D-U-N-T. It's been all over social media, and those of us who enjoy the not suitable for work contributions he makes on Romaniacs and the Bunker will have needed little urging to buy the entirely suitable for work book. It's really fascinating, for me at least, filled in large gaps in my knowledge, and also, it articulated or explained some of the frustrations I certainly feel about the direction of politics and this country, the direction for this country at the moment. So, a big plug for that book from me. Finally, as always, it only remains for me to confirm that no Liberals were harmed or otherwise mistreated in the making of this podcast. Thanks very much indeed. Take care all. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.